mythical Linturi's wedding in any other place called a certain church?
He did officially was also done with Your Honor.
Let's proceed to the third question. I praised you that you know very well the canon law. Do you have any, as lawyers we deal with the laws of this country, is there any canon liturgy or knowledge or a document under the Catholic Church that deals with how to conduct marriages?
Yes, Your Honor.
What is the name of that document?
It is called the rights.
Let the court get it. It is called the rights. Only that.
The rights of the marriage.
Rights of the marriage. That document, which you know very well, is roughly how many pages?
Over 200 pages.
It is over 200 pages. Who is the author of that rights to marriages?
It's the Catholic Church of made by the Catholic Church.
I want the court to get it.
It's made by the Catholic Church. Your Honor.
It is a document for the Catholic Church.
Legal document.
It's a legal document. And it's a document that explains every procedure in a Catholic marriage.
Yes, Your Honor.
What does it say for people who have children and they want to do a marriage under the Catholic Church? What does that document say?
Your Honor, there's no problem with children.
No. What does it say? I've not said whether it has a problem or not.
Your Honor, I'm not aware of that phrase discussing about a person with a children related to marriage. Because of marriage is a provocation.
Answer my question. Do you know the provisions and the policy document, what it states on people who have children outside they want to conduct? It's either you know or you don't know.
Your Honor, the document talks about taking care of the children whom you have and not whom you have.
Does it stop anybody who has a child outside from conducting a Catholic church?
What's Your Honor, so that we are not in a wild-goose chase? I'm of course aware we're in cross-examination and that the scope is fairly wide. But even at its widest point, cross-examination is still subject to the rule that the evidence being elicited must be relevant evidence in the sense of evidence relevant to a matter in issue. There is no question on the pleadings in the case before you on questions of canon law. The Honorable Mythical Linturi was married under the African Christian and Marriage and Divorce Act. The church is only a representative of the state at that forum, which is the place of worship. And that's why the returns of that marriage are made to the state. Unless counsel can show us, because in my view, and I'm projecting to us, Your Honor, Section 5 of the Evidence Act, it says, subject to the provisions of this Act and of any other law, no evidence shall be given in any suit or proceeding except evidence of the existence or non-existence of a fact in issue. The fact in issue is whether the Honorable Linturi is married to the lady called Marianne Kitany. And of course, there is another fact in issue which is raised by the defense, that marriage, Marianne Kitany alleges, cannot be, because the Honorable Linturi lacks capacity anyway, by virtue of his prior marriage to Mercy Femeni. So the marriage to Mercy Femeni is not a marriage under canon law. It is a marriage under the temporal laws of the Republic of Kenya. And specifically, a marriage under Cap 151, now repealed and replaced by the Marriage Act of 2014. The reason I'm saying it is irrelevant evidence and prohibited by Section 5, even if it's elicited, it will just be wasting your time. Unless counsel can ask this witness questions showing that the marriage between the Honorable Linturi and Mercy violated the provision of Cap 151, unless that is the question, questions of whether it violated or did not violate canon law or whatever other phases of law is irrelevant. It is irrelevant evidence, and by statutory decree, specifically Section 5, that evidence is inadmissible. So it doesn't matter what answer the witness gives you, it is a waste of our time.
Your Honor, it has also come to a conclusion. There is someone who is unemployed. And if that's true, then we'd like the court to intervene. If it's not true, then we apologize in advance. We told that there's a gentleman who is armed. It could be speculation, but we need to be safe because the world is full of terrorists. Anything can happen. So we don't want to apologize in advance in case it happens.
Now let me deal with the question of guns as a matter of laughter. These courts are manned by the National Police Service. They know their job. I know Professor has been a police officer sometimes. He's more sensitive to guns, but that is not what we let us not cast aspersions on people who have been clear to be this court.
Your Honor, even members of parliament are not allowed to come to court with guns. And that's why we have security to protect. It matters less. It matters not. Even if the court is here and is armed. If the police officer is in the building, is in the house and is armed, we need, probably in our opinion, we need
You know, that's a very serious matter. Speaking of myself, I don't carry guns. But I want to hope it's not true. I think this is a matter we must actually address exclusively. We can't just brush it off. It's elementary. No one should really attend court armed. So as Prof can tell us, the person he thinks is armed. If it turns out he's not armed, then we just move on.
Let me respond to that now. The councils are pushing it further. We raised the questions about the attempt by a senator and his team to kill my plant. It is on record. The court has records of the life of the petitioner. It's in danger, just like it was to the house girl who died. We have produced obis about the life-threatening instances of the petitioner. The question about her security is not an issue that is not known to this whole world. And I'm on record that I've been representing clients who have been found in septic tanks. My client is one of them, whose life is in danger. From the respondent, she has taken her own security initiative and measures. If anybody wants now to actualize that murder so that she's exposed, we will object very seriously. She has her own security arrangements which have made her to be alive to see this day. The prayers of Father cannot assure her life. Therefore, Your Honor, for the security of the petitioner, which is a national question, it cannot be granted by the respondent who has provided the life-threatening threats to the petition. And let this court not be used to interfere with the security arrangements that are in place, so that the respondent is able to understand what security measures have been placed to protect her life. I believe there are very many police officers here, within, marked or not marked, and that should not be an issue this court. May the life of my client be protected. I made the same noise for Cohen, he was murdered. I'm making the same noise today for this petitioner. I made the same noise last week for Jane Mugo. This is our trend in this country. Your Honor, we wait for your directions over that matter.
The only thing I've had my colleague is actually confirming that there is a person present in this court at the instruction of Marianne who is armed. That being the confirmation, Your Honor, that person must surrender the firearm through the usual channels used for people to surrender firearms when they enter a court of law, and they'll get back their firearm when the court session is over. It is not the policy, it is not the practice of our judiciary to allow harmed persons to be present in a court of law. The court is a court of justice, Your Honor. Even the symbolic implications, the mere symbolic implication of someone being present in a court and harmed is itself inconsistent with the idea of the independence of the judiciary as it has evolved from the common law days. Not even the king's soldiers, Your Honor, I'm taking you back to antiquity, a medieval times. Under the common law legal system, not even the sovereign himself can come to a court of law armed, leave alone a subject of the sovereign. Not even the President of the Republic of Kenya, Your Honor, is allowed. It is an assault on the stature, on the independence of the judiciary. It is an assault to the idea that the judiciary is the fountain of justice where everyone, the strong and the weak, run to. People don't run to a court of law based on their might or their weakness. Everyone is subject to the rule of law. The judiciary has a policy on this, it has a practice on this, and to the best of my knowledge, when I have walked to a court with people who are armed, the protocol and the procedure is they surrender their firearms to the judicial security, and when they exit, they take back their firearms. That's the procedure. Speaking of myself, I think it would be a sad day. I think this case has stretched so many limits on, and I think the petitioner thinks she can continue preaching. We are thinking about live broadcast, hearing a family matter in open court.
Let me object. Just interject. And bring the following direction to save on time.
Yes.
Because we want to save on time. We will be here to seek delivery of the same issue. And we will say that the judiciary has a policy on issues of handling of fire in oppressive. This court has stand, it is not the duty of this court to do the frisking and all manner of things. Ours is to ensure compliance. There are experts. The name of the OCPD and the OCS we have an OCPD here who sits at home, but they man the security of this court. So we call upon the OCS and we have sent a message that he may investigate and the issues raised and take appropriate action where possible, so that the policy of the judiciary as regards and even their whole gap in handling of arms. That may include, we have yet to know whether they handle and we don't know. Because, yeah, we do not know. So let the experts do their work. And we call upon them to come and see what they can do. But for now, let's continue with our matter. We are called. They are here. In fact, I don't know where that is. It's supposed to be here every other time. But we have called on.